Welcome to Rebel Chaser. My name is Gail, and I have a part 2 for you from a clip in Judge Nelson's courtroom. This is the woman who said, "Send me to jail. I am not paying my back child support." And the child had aged out in 2011. So this child is now 31 years old, and mom still is adamant she is not going to pay. So I will pin in the comments the part 1 so you guys can see that if you'd like. But here is part 2. I'll let you guys watch.
Of course, now on the record, and this is Bell County Cause number 176,990-A. This is in the interest of Sheldon minor child, non-custodial party being Ronnie Yvette Houston, aka last name Snow. Court will know for the record that this is originally filed by the state on a motion to confirm child support arrearages. The court will know for the record that both parties in this matter have previously been noticed and served. Looks like this original cause of action was started back in 2018. Has been going through the court for a while. Anyway, the court will know for the record that Ms. Snow has filed several written responses in this matter. Court is going to, before the hearing's over, confirm whether or not that those items were actually forwarded and noticed to Mr. Sheldon and the state in accordance with the Texas Rules of Civil Procedure. But at this time, I'll go ahead and ask the state for an opening to tell the court what the state is requesting we do here on the state's pleadings. And then obviously I'll allow the parties to make an opening statement this time, since the mother has filed, Ms. Snow has filed so many items in her own behalf. So I'll go ahead and let her make an opening statement of what she's requesting the court to do. Because she's our own pro se representative. And I'll also give Mr. Sheldon that opportunity if he wishes. So at this time, I'll ask the state to start with their opening statement. Thank you.
Yes, thank you, Your Honor. Stratos Apostolo with the Attorney General's office. Your Honor, we filed a motion to confirm. This is all arrears. Obviously, the child's aged out a while back. The court actually had a hearing on April 18th, 2024. And my understanding is temporary orders were entered and an NCP choices referral. It looks like the only thing actually pending for the court today to finalize that order is a review of the payments on that judgment. I can see at the bottom of page 1, it said the court will reserve or review those payments on the money judgment that was rendered. So that's really the only issue for the court today. I wasn't personally at the April hearing. I did have a chance to talk to the parties, and I wondered if mom, presented evidence or not, or if that money judgment is final and can't be any other evidence presented at this point. But that's kind of the only thing I see pending is the payment on that money judgment.
At this time, have you been made aware of any objections or counters that the either parties are requesting at this time?
I'm sorry, you were addressing me, correct?
Yes.
Yes, and Your Honor, Stratos Apostolo AG's office. Yeah, so it's still Ms. Snow's position that she doesn't know anything after a brief discussion with her, and it's still Mr. Sheldon's position that he wants to collect.
All right, thank you. Ms. Snow, opening statement, ma'am. Thank you.
Okay, well, as I stated in our last meeting, that I paid already. I did submit the receipts that I were able to dig up, where I did send in probably more than what you're saying I owe. So I'm saying to you that there is no arrears for this account. At least there should not be any arrears for this account, because whether it went through the Attorney General's office or no, they were paid. They were paid. Okay, now I'm in a position where I cannot pay. There is nothing else to be paid. Okay, in fact, they may owe me some money back while I'm thinking about it. Okay, so again, I move to cast judgment that this child support is moved to $0 per month, being that I am currently in a state of dire straits, really. Currently, I am in severe dire straits, and there is no money to be paid. I have no way to make pay any more payments on this account. I've been paying on this account since my daughter was like 2.
Stop, Miss Snow. You're yelling at me, and I'm going to yell back, and I'm the guy that can yell. Understand? Lower your voice, make your opening, and stop testifying, ma'am. I know you're not a lawyer, but then you've gone into testimony. At this time, I've already looked at making a judgment in this matter, ma'am, and I'm not seeing anything unless you can show the court evidence that you actually paid the funds you're saying you did through the state disbursement unit. You got a problem.
Well, I've always...
Ma'am, again, I was just asking for an opening. You asked the court to find you at 0. I'll take that as your opening, and we're going to go ahead and get some more testimony to confirm that one way or the other, ma'am. Thank you. All right, Mr. Sheldon, I don't think you need to make an opening, sir. Obviously, you want the state has requested that you be repaid based on what the records show, and we'll take it from there. So at this time, Ms. Snow, Mr. Sheldon, please raise your right hand. All right, do you both solemnly swear or affirm testimony you're going to give here today is the truth, the whole truth, and nothing but the truth so help you?
I do.
Yes, I do.
All right, you're both officially on oath and allow the state to proceed. Thank you.
Thank you, Your Honor. Your Honor, if I may first share my screen.
Yes, you may.
Your Honor, what should be showing up on my screen right now is a document marked for notification purposes as CSD Exhibit A, the pay record in this cause. We formally admit into evidence what has been marked for notification purposes as CSD Exhibit A.
All right, folks, I've got the live copy here with me. The copy that the state is showing is the official financial activity report under this cause number for the state of for the Attorney General's Office of the state of Texas. Is there any legal reason that this should not come into evidence at this time, Mr. Sheldon?
No.
Ms. Snow, is there a legal reason that this should not come into evidence at this time, ma'am?
No, I don't think so.
I'm sorry, ma'am?
I don't think so, no.
There's no legal reason?
No.
Okay, states A is admitted. You may proceed, Mr.
Thank you, Your Honor. Your Honor, I'll go ahead and call Mr. Selden. Mr. Selden, please state your full name for the record again.
Bobby Lee Selden Jr.
And Mr. Selden, you are the custodial parent payee. You're the one that's owed child support. Is that correct?
Yes, sir.
Okay. And we were here in court in April. Did Ms. Snow present some evidence to the court about maybe payments she didn't pay through the registry?
Yes, she showed some, I guess, some printouts of money orders for certain amounts, and I never received a money order, so I don't know where, if where the money went or nothing. I never received no money order through the mail.
Okay. And Mr. Selden, when Ms. Snow was working, we were actually garnishing it and you were getting payments through us, correct?
Yes, on my card there has been some payments on there.
Okay. Has she paid you anything directly since the last court date in April?
No, sir. No, sir.
Okay. And Mr. Selden, are you aware that the court order says that you're supposed to pay the support through the registry, and anything paid outside of that is a gift?
Me?
Okay. But you don't, there's nothing that you would credit Ms. Snow in terms of any kind of direct payments that you receive outside of us.
Right.
Okay.
I never received any kind of direct payment.
And that's why you wouldn't give credit, because you're saying you never received them. Okay.
Yeah.
And you saw the document that was admitted into evidence. It's showing $10,940.86 as of June 20th, 2024, that is owed in child support against Ms. Snow. And you want to collect every penny of that, correct?
Yes, sir.
Okay. What does Ms. Snow do for a living?
I do not know.
Okay. Okay. You know anything about her financial situation?
No, sir.
Okay. You have any idea, or do you have some request that you want the court to order her to pay every month to liquidate that judgment?
No, I did this. It was it. It basically started out as $100 a month.
Okay, so it's at 50 right now under temporary order, but $100 a month you think is fair?
Yeah.
Okay, I'll pass the witness, Your Honor.
All right, thank you very much. Be back in a moment, sir. I'll allow the state to call your next witness, please.
State calls Ms. Snow. Ms. Snow, please state your full name for the record.
Ashalayan Ronnie Yvette Harris Snow.
Okay, and ma'am, you were here in April, and did you get a chance to present some receipts or exhibits about direct payments in April?
Did I submit any payments for direct? Yes,
To the court?
I did.
Okay.
Yes, I did. Yes.
Okay. Do you have any further evidence that you want to submit to the court today about alleged direct payments?
Any further evidence? No.
Okay. All right. And you heard Mr. Selden's testimony about how he said he's never received anything directly. How do you respond to that?
Well, I really don't know, but I do know I sent in those payments. So if he's saying he didn't receive them, that's not on me. So that's just, I can't prove that he received them, and he can't prove that I didn't send them when I did. Okay?
Okay. So, Ms. Snow, usually the child support orders have you paying to the registry for this exact reason, because people will say, I didn't get it or I got it. Why didn't you pay everything to the registry?
Because the last time I was in court, the person that was in your position right now showed me where it was on the orders where I should have paid through. However, in my paperwork, I didn't have that part. I didn't have that part of the paperwork.
Okay, all right. Anything else you want to add that I haven't asked you about, Ms. Snow?
Well, I am still unemployed, and I know that in this court, through this system, that is not a valid reason, but there is no money for me to pay. Okay?
Ms. Snow, they refer. Oh, okay, I'm sorry. Go ahead.
No, I'm done. Go ahead. I mean, our last meeting was recorded, so everything I said on my last meeting still stands today. So I'm gonna speak softly because I don't want to elicit any emotional responses. But at this point, I am unemployed. There is nothing to be paid out. I believe I have paid more than my share. Okay.
And Ms. Snow, they asked
you.
They entered you into what that's called the NCP Choices program to maybe try to find some employment. Did you participate in that or no?
No one contacted me or entered me into anything.
Okay, all right. I pass the witness, Your Honor.
All right, ma'am. Well, I did finally find in your old order. It was done by private counsel back in the day. And it was ordered that any and all payments should be made through the Bell County Child Support Office at that time. Did you, and are you alleging that any of these amounts were actually paid through either the State Disbursement Unit or the Bell County Child Support Office, or that you sent these payments in directly to Mr. Sheldon?
The payments were the payments that I'm speaking about that they're saying is back payment. Those payments were sent directly via mail to his house on file. At the time, I was in Germany, and those payments came in through the U.S. mail. Now, if he's saying he didn't do them, I have no way of proving that or no. All I know is that they were sent.
All right, here's the deal, ma'am. Back in when you did this, the state disbursement unit was there, but it wasn't full blown. Your case was a final through well, it was a private account, a private attorney matter, and you were ordered to make any and all payments to the Bell County Child Support Division at the courthouse. Now, anything you made directly, it also says that you may not get credit for if you did not pay through the appropriate facility. And if you sent them directly to him and he says he didn't get them, then I can't give you credit for them, ma'am, because there was at that time an official county registry for paying child support, and that was in your court order, ma'am. Do you see that?
I'm sorry.
Did you see that?
No, I did not see that. I was informed of that the last time you had me in this courtroom by the person that had me in the breakout room. Okay, I did not know. I mean, because I didn't, as I said,
for you to get proper credit, you had to do it through that. So at this time, ma'am, I cannot give you credit that you allegedly sent to to the father, and he says he didn't get them.
Okay, but he said that last time we were here, so.
Okay, well, you brought up something that I wanted to double check. That's why I wanted to check your court file, because you said you didn't have that in your order that you were to pay through the state disbursement unit, and you were correct. You were ordered to pay through the county child support disbursement unit, technically, and the state took that over, and they're not showing up on either of those readouts, ma'am. So at this time, I cannot give you credit. I've got to go ahead and looking at reducing that to judgment. And the original amount of child support was $100. So I'm going to go ahead. I thought it was low, but I'm going to go ahead and reduce the judgment, the amount as in States Exhibit Number 1, and order child support repayment at an additional $100 a month starting the first day of July until paid in full, ma'am.
Okay, well, I've already put in a request for a reduction because I can't afford the $100.
Well, ma'am, I know you filed a lot of paperwork, but you've got to you filed it, but you actually have to serve Mr. Sheldon through citation on those items, ma'am, before the court and notice the state before this court can take them up. Just like you got served a copy of the paperwork in this case, you got to do the same thing on any motions you have, ma'am. All right? You're your own lawyer. You got to do it just like a lawyer. So anyway, for right now, ma'am, the judgment's in full. The repayment is $100 a month, starting the first day of July. I will note your financial circumstances, and I'll waive court costs. All right. Is there anything else at this time, Mr. Sheldon?
No, sir.
Is there anything else from the state?
Your Honor, just so the parties are clear, I'll draft this order and they have 72 hours to sign. And then if they don't sign, I could submit to you on Monday.
Correct. All right. Anything else, Ms. Snow?
No.
All right. All right. Thank you both very much. And sorry for the delay, but I wanted clarification because I knew there was an old order. I saw Judge Carroll sign it and Judge well, I think Judge Adams even signed it at one time. So anyway, I'll go ahead and allow the state to prepare that order circulated by DocuSign, and ma'am, again, signing off on it doesn't stop it, but it's just, and it doesn't say you agree to it. It's just saying that this is what the court ordered. And I'm going to go ahead and at this time I'll go ahead and confirm that the state it's okay with the state that both parties sign off at this time, correct?
Yes, if they would please sign off. If not, I'll submit the order Monday, Your Honor.
All right, both of y'all are free to go, and we're off the record. Thank you.
Thank you.
Thank you.
You know, I wonder if this mom has any kind of relationship with the 31-year-old child. I hope so, but for some reason I get the feeling she doesn't, but I hope she does. Anyway, I will pin part 1 in the comments, and thank you so much for watching. I'll see you next time.